Have you ever wanted to take it to the Supreme Court? Well, we'll tell you how that works. I'm Dan Ringer, and we'll talk about the revised rules of appellate procedure right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
The West Virginia Supreme Court is adopting revised rules of appellate procedure. Does that affect you? Yes, it does. My guest is the clerk of the West Virginia Supreme Court of Appeals, Rory L. Perry II. Rory, thank you for joining us.
It's my pleasure to be here, Dan.
Of all that we've heard about the Supreme Court over the last few years, now you're changing the rules. Why? What is the revised rules of appellate procedure?
It's a very good question. The rules of procedure are the rules that govern how the court works. And the court in 2010 is a very different place than it was in 1864 when the state was founded. The Supreme Court of Appeals has constitutional authority to write its own rules. Many people don't realize that. And there are actually 23 different sets of rules that the court has written that govern all different sorts of procedure.
Since 1864?
Yes, throughout the state. There are right now 23 sets in operation. The very first set that was written, though, had to do with the work of the Supreme Court, the rules of appellate procedure, we call them. They were first written in 1864, and they really haven't been revised in over 30 years.
So, regardless of what's happened with the way people travel or the way documents are prepared, these things don't change very quickly.
They certainly don't.
30 years ago was 1980.
That's right.
I didn't have a computer in 1980.
Well, a lot has changed, and a lot about society has changed. And you know, there's a lot more interest in the public and in the press on how the courts work.
We probably ought to lay a little groundwork. In most states in the United, in fact, I think in all states of the United States, most governments around the planet have three separate branches of government. We have the legislative, who enact the laws. We have the executive, that would be in West Virginia, the governor, who execute the laws. And then you have the third branch, and that's the judicial branch. And in West Virginia, that consists of magistrate courts at the lowest level, family courts and circuit courts at basically the county level or the circuit level. And then we have the ultimate court, the Supreme Court in West Virginia, the Supreme Court of Appeals.
That's right.
Now, these rules are being revised. Why?
Well, there's really at least two good reasons for that. One, we've already mentioned. The rules are outdated. They're in part based upon some archaic procedures, and they need to be modernized. In addition, the court recognizes that there's an increased need for accountability and transparency in government. And the way that Supreme Court cases operate shouldn't be shrouded in mystery or just part of the lore of the bar. So there's an increased need to make the rules easy to understand, straightforward, but also preserving important rights both for West Virginia citizens and for how cases move through the Supreme Court.
Well, how's that going to happen? How's the Supreme Court's operation going to be more transparent?
Well, you have to sort of back up a little bit and talk about the way appeals work right now. In West Virginia, we're one of 11 jurisdictions in the country with a single court of last resort, without any layer in between the counties, if you will, and the highest court in our state. And with that, the court has high amount of discretion to examine cases and decide whether to bring them in and write a full opinion. So we have a system right now called appeals by permission. you have to get permission in order to have the court review your case and have full oral argument.
We ought to digress just a moment. In West Virginia, if you have a court case, you can start it in a couple of ways. One, if it involves a relatively low amount of money or a relatively simple issue, you may start in the magistrate court. The magistrate court some years ago used to be referred to as the JP court or the Justice of the Peace court. That system was changed in, I believe, the early to mid 70s.
That's right.
In some places that's called small claims court. The next court up, or the entry level for more significant matters, is the circuit court. Now, the circuit court is the court that's found at this county seat or in the county courthouse. The circuit itself may be more than one county, but it's usually one or two counties, adjoining counties, where the judge or judges move back and forth between the county seats. After a case is decided in the circuit court, there is no other review of that case except in the West Virginia Supreme Court of Appeals. Unless it's a very unusual circumstance, it might take it into the federal system, but that's a completely different thing, and that's not what we're discussing today. So I have a case in the circuit court that I want to bring to the West Virginia Supreme Court, and I have to bring that in accord with the rules of appellate procedure.
That's exactly right. The Constitution, again, gives the court the ability to set its rules for procedure, and under those rules you would file an appeal, setting forth written reasons why you think the circuit court made a mistake, either of law or of fact. And the justices and the staff carefully review those written arguments. And it's important to remind people that at the Supreme Court there's no new evidence taken, there's no new witnesses who appear. In essence, an appeal is based upon written arguments only.
So I don't get to say the trial just wasn't done right at the circuit court. I want you to do it again.
No, there's no real do-overs. At the Supreme Court, everything is looked at through a standard of review, in essence. So the Supreme Court is not really permitted to second-guess the trial judge or second-guess the jury. And that's why everything is restricted to the records and the papers. And that's why the rules are important. And one of the things that the revised rules are doing is taking it from an appeals by permission to an appeal of right.
Appeal by permission. What does that mean?
Appeal by permission, right now you have to ask the court to file the appeal. The petition for appeal is reviewed. And if the Supreme Court believes that it's a case that should be argued and result in a full opinion that will bind all of the courts in West Virginia, then it will let the case in and we'll have a second round of argument. Under the new system, all cases will result in a decision on the merits. No cases will be refused.
So under the present system, I would file a document, a petition that says, I want you to review this. I think some things were done incorrectly here. And the court would look at that and say, okay, we'll talk about it, or no.
Or no, we won't.
We won't.
And so what happens is let's say in criminal cases, for example, only about 20% of criminal appeals right now are let in for argument and a full opinion. The remaining 80% are reviewed carefully, but then refused without any reasons being given as to why the court refused the appeal.
So there's nothing that comes out that says, you may think this was done wrong, but here's why it was right.
Exactly. And so what the revised rules of appellate procedure do is they require a decision on the merits with reasons in every case. So in other words, if the Supreme Court is going to say, we think the lower court was right, it's going to explain that in a written order with reasons. In contrast, right now, in many cases, the court just issues an order that says your appeal is refused. And that can be frustrating for the parties involved and for those of us who work at the court.
Well, I know a kid will come to his parent and say, I want an ice cream cone, and mom will say, no, and he says, what do you mean, no? Why can't I have an ice cream cone? And the same sort of thing happens with the Supreme Court. I want you to review my case. I think the outcome was wrong, and under the current system, the court just says, no.
In some cases, that's true. Now, that's not all that uncommon. That's what the United States Supreme Court does. However, The nature of the court's caseload and the nature of the changing modernization of people's expectations, the court felt it was important to revise the rules of appellate procedure, because one reason it's frustrating for the court is the court works very hard to review every single petition for appeal. It's just that in some cases those appeals are refused, which means the lower court's order stands. And by issuing a written decision on those cases, all of the work that goes into reviewing the case will be more obvious and more transparent to those who watch the courts.
Rory, it seems like, though, that would be a pretty significant increase in the workload on the court. I know when we invented computers and we started using them in the office, the first reaction everybody had to it was, well, we've got computers now, we'll be able to write things much more quickly. And what we found out was, no, it still takes the same amount of time. You just revise. You may get a better written product, but it takes a lot of time to write. And now the court, where under the current system may internally know the reasons why my appeal's being denied, to actually have to write it down and send that opinion out, it seems like that would take an awful lot of extra effort on behalf of the court.
Well, it may seem that way, and that's a fair point. And we'll all be working harder, but we'll also be working smarter. Because the work that's being done to review the case internally is not obvious in the final product that is issued. And so, yes, it's going to take a little bit more work, but it's not going to take a vast increase in staff or personnel at the Supreme Court.
It's just going to be kind of reassembling work that's already being done.
That's correct.
Into this opinion to send out.
Mm-hmm. That's true.
Well, how does the appeals process work under the new rules then?
Well, under the new rules, if you disagree with the circuit court decision, you would file a notice of appeal within 30 days, setting forth some basic reasons and letting us know if any transcripts are necessary. Again, because the evidence and the witnesses are not available at the Supreme Court, we have to go on written documents, transcripts, papers filed in the lower court.
And that's basically the way the current system is.
That's true.
If I want you to review my case, I have to provide you with the documents to review.
With the documents. Exactly. And then within 4 months of the order that you're appealing, you would have to file your appeal. And in that's really the essence of the appeal. You have to set forth your written reasons why you think the lower court got it wrong. And one of the major changes in the new rules is to require lawyers to provide the court with an appendix of the record. Now, the record on appeal is very important at an appellate court because the Supreme Court can't second guess what the circuit court did. It can only review the record that was made in that lower court. They can't substitute their own judgment. So for over 100 years in West Virginia, lawyers provided the Supreme Court with the record. This little booklet on the table here is an example of a railroad appeal from McDowell County in 1924. This would have been assembled by the lawyers and sent to the Supreme Court as an example of all of the evidence that was pertinent for the court to consider. This was done away with in 1971. Back in these days, Dan, folks had to send their materials to a printer. It was typeset and bound in these documents. Talk about how office technology has changed. Now people can produce these with photocopiers and in their own office. But because it's very important for the written arguments to be clear and tied to the record, we're asking lawyers to prepare an appendix of the record on appeal in their case, instead of just having a box sent from the circuit clerk's office to the Supreme Court and maybe not as carefully prepared.
Yeah, under the current system, and I've seen this done several times, the lawyers would just tell the circuit court clerk, send the entire record. The boxes would be unfolded, the stuff would be put in it, and a truckload of things would come down to the Supreme Court without particularly any instructions on how to assemble the case from that.
And then you have the written arguments filed by both sides, and it's difficult for them to make sure that they're tying that carefully to the record. And because, again, the Supreme Court can't look at any new evidence, it's bound by what is in the stack of paper in the file, it's very important to tie those things together.
And the court's ability to find in the file the material that might be germane Under the new system, the lawyers have to say, this is the fact, and here's where you will see that in the record from the circuit court. It's like having to footnote every sentence in a theme. It's going to be a lot of work, I would think.
Well, it's going to force lawyers to think more carefully about their issues on appeal and result in a better quality process. The court is changing the way that cases are being briefed, so it's important that they get it right the first time.
What do you mean being briefed?
Well, briefs are what we refer to as the word we use, in essence, to describe the written arguments that are made by parties to an appeal. And right now, only one side really has to file a brief. Under the new system, both sides will have to participate and file written arguments.
So under the current system, if I want you to accept my appeal, I have to write a brief about
You have
the
to
case?
write a brief about the case, but the other side can respond or they can elect not to. Under the new system, the other side will have to respond in some fashion, either by filing a formal brief or an informal brief in some circumstances. And both sides will cite to the same record, appendix record that we will have, and then the court will examine the case in conference, and it will either decide the case on the merits by issuing a written decision, not a refusal order, as happens now, or it will set the case for oral argument and later issue a written decision on the merits.
One of the things that has been historically true about writings in appellate cases, we call these arguments from each side briefs. They aren't brief historically. In fact, for a lawyer in practice, it can be one of the most complex pieces of writing she or he ever does.
That's true. That's absolutely true. However, the most effective briefs are the ones that get right to the point. And so we hope they're brief, but they're not always brief.
Well, you're actually providing some guidance on how long these things can be, too.
Yes.
Putting page limits on them
Absolutely.
and that sort of thing. Shorter page limits, because they're not unlimited.
Not unlimited, but you know, if someone needs some extra pages to make a complex or specific argument, the court can grant them extra pages.
So under the old system, we had permissive appeals where if I was the lawyer doing it, I had to file these preliminary documents with the court, and the court could say, no, we choose not to hear this case. But under the new system, I'm going to file my documents, the other side is going to file their documents. As I understand it, then the court's going to review both sets of documents, and then they're going to decide whether they want to hear oral argument.
Right. Oral argument is an important component of what the court does. But not every single appeal is going to benefit from having oral argument as part of the decision process. Very few appeals courts in the country permit oral argument in every single case. So instead of automatic argument, the court is going to decide first whether or not maybe it's a straightforward case without any new issues and argument really isn't going to help the decision process. And in those cases, the court will simply issue a written decision. In other cases, we'll have two opportunities for argument. One track will be for cases where the court thinks that a written decision on the merits will issue, but does not believe that any new points of law will arise from this case. You spoke about the three branches of government, and one of the things that you mentioned was the executive branch executes the laws, the legislative branch makes the statutes, and the judicial branch interprets the Constitution, and they also write the common law. So courts do make law. They make the common law, judge-made law. And in West Virginia, the Supreme Court does that through a specific type of process in its opinions that's required by the Constitution, and that's called syllabus points. These are outlined points at the beginning of an opinion, and if it's a new point of law that has not been announced before, because society does change and circumstances change, the court will do that in an actual syllabus point in an opinion. Well, not every case plows new territory. So cases where oral argument will help the decision process, but the case won't be plowing any new territory, those will go on an argument docket we call the Rule 19 docket, named after the rule that governs it. The other cases where new law will be made will go on to the Rule 20 docket.
And the Rule 20 document?
Those are cases of first impression, important constitutional issues, statutory changes, and the cases on that docket will more than likely result in an opinion that has a new syllabus point or another type of per curiam opinion that makes law statewide and informs the public and the bar about important changes in circumstance.
You started speaking Latin to me.
Sorry.
No, that's quite all right.
Tried to avoid that,
what does per curiam mean?
Per curiam is a term of art that we use in the appeals court racket, so to speak, that describes by the court. No one particular justice authored that opinion. And in West Virginia, what that means is that a per curiam opinion does not have any new points of law, no new syllabus points. It has syllabus points, but it merely quotes those points from prior opinions.
One of the things that happens during oral argument, well, a couple of things that happen during oral argument, is when the lawyers appear in front of the court may ask if they have any information that's not already contained in the briefs. Ideally, a lawyer's going to say no, because you've done the best job you can to put all of the information into the brief, but between the time the brief's prepared and you actually get in front of the court, you may have thought of something in a different light, something may have occurred to you, you may have learned of additional information, not necessarily about the case, but about society as a whole that would be worth bringing to the court's attention. But the other opportunity during the oral argument is the court can ask questions. And especially in cases where it's a new issue, things haven't been considered before, I would think the court might very well have questions that need to be answered, and that's a purpose for the oral argument.
Absolutely. And with 5 justices on the court, the questions can come from all 5 of them. Maybe not at the same time, hopefully, if you're the one having to answer them
at the same time.
But yes, that's a big part of oral argument, especially, as you said, in instances where there might have been a new case, maybe the United States Supreme Court comes out with a new case, and then the justices want to know from the lawyer who's arguing, how does this affect your situation?
It can be very complex putting together legal arguments because the law changes constantly. That doesn't mean that the speed limit out on the interstate changes because the law has changed. It means that the way the law is applied changes constantly. You were talking about the justices of the Supreme Court making laws, making the common law. The common law is law that is common throughout the jurisdiction, but it's the law that is expressed in judges or appellate court, in this case, opinions. There's a lot of criticism of judges, particularly appellate judges, of legislating from the bench, of making law from the bench. That's inescapable.
In large part, yes, but it's not as common as people realize, because I don't think that courts are not very well understood, and because there are special rules that apply to judges, the courts can't always respond to critics very clearly like other branches of government. But most of the common law that's made is not legislating from the bench. Legislating from the bench would be something where the courts are setting public policy, trying to decide public policy. As many people say the United States Supreme Court did in the Brown versus Board of Education case, which is the one that's often cited as the Supreme Court making, not the West Virginia Supreme Court, but the U.S. Supreme Court making public policy. And there are always, from time to time, there will be cases that are on the margin. But in my experience, almost 10 years as clerk, most of the opinions of the court no one pays any attention to. They're pretty run-of-the-mill, and they're applying existing law to new fact situations. In fact, Dan, most of the opinions issued now by the court don't make new law. In the 90s, the number of per curiam opinions, there's that Latin word again, the number of opinions without new points of law began to exceed the number of opinions where new points of law were made. So the courts are actually, the West Virginia Supreme Court anyway, is actually making less law now than it was for most of the time that it was in existence.
What happens when cases are litigated very often is that you have a particular fact pattern and you have written laws, and the question is, how does this law apply to this fact pattern, or how do these facts apply to the law? And I suppose in a perfect world, the legislature would get together and they would clarify the law to say, yes, we intended that horses and cows be treated equally, so they would change the law to say livestock instead of cows, or instead of horses and cows. But it takes time for that to happen. Sometimes it takes years for that to happen, and my horse and your cow were involved in this thing, and we need to know what the law is. And that's what judges do, what justices do on appeals. Rory Perry, thank you very much for being with us.
It's been a pleasure. Thank you.
Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find video of this program at thelawworks.org, and you can find previous programs on YouTube. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.